Hello and welcome to the ICOVISIONS podcast. I'm your host, JM Crypto, and today I have a very special guest with me going by the name of Chetan Phull. Hello, Chetan.
Hi.
How are you?
Good. How are you?
Great. Great to have you on here. Maybe you can give me a formal introduction as to who you are and what it is that you happen to do.
Thanks. So my name is Chetan Phull. I am the founder and a blockchain and IT lawyer with Smartblock Law Professional Corporation in Toronto. And we focus on blockchain law, cryptocurrency law, IT contracts, and litigation. Today's talk, as I understand it, we're going to be focusing on blockchain and cryptocurrency issues.
Right. There's certainly, a lot of issues to, I guess, be addressed, and having someone like yourself to happen to address those issues is certainly a pleasure. And thanks again. Maybe you can, take us through some steps for which people should actually be taking, even companies, as it applies to them and issuing their own cryptocurrency and even rolling out their own ICO.
Sure. I would like to just give an overview of this area of law and then put ICOs and ITOs within the context of this area of law, if I may.
Sure.
So the entirety of blockchain and cryptocurrency law, there are three main legs. One is the funding and capitalization portion, and so that is where your ICOs and your ITOs, any big funding securities laws issues come into play. The second leg or branch is operations issues, and that includes things like anti-money laundering issues, taxation issues, issues regarding IT contracts and node contracts, mining coalition agreements, data privacy, all those sorts of issues, and I'll be talking about those as this talk proceeds. And then finally, the last leg of blockchain and cryptocurrency law is on the enforcement side. So that involves litigation and arbitration whenever things go splat and a dispute arises between parties in the blockchain and cryptocurrency morass. So I deal with all of these issues, and I'm happy to talk about any one of them, but today I'm planning on focusing on some of the key issues that arise in almost every blockchain and cryptocurrency business plan that comes across my desk today. So the first big topic is securities issues, and everybody seems to be focusing on this, and there's a lot of curiosity on these issues. So I'm going to begin there, and then we'll move on to the other issues. I should state that I don't want to focus too much on just securities issues because it's so involved that this entire talk could be just securities issues.
Right.
So for now, I'm going to keep it to the salient points and then move on. But in a nutshell, securities issues will apply, at least in North America, in every jurisdiction where you have an issuing company. So that's the company who's issuing your tokens, and you have investors, and those investors are people that buy your tokens. And it's thought that if you're compliant with securities law in one jurisdiction, that you don't have to worry about anything else in terms of securities compliance, and that's just flat out not correct. So the truth of the matter is, with any ICO or ITO, you're going to need a compliance campaign that will cross jurisdictions. Most blockchain companies operate in more than one jurisdiction. And if you plan to operate in more than one jurisdiction, you're going to need compliance in both. And we know that that's the case because the SEC chairman had stated that there's no plan as of right now to regulate securities tokens any differently than the securities laws that are in place. So the existing securities rules will apply, and we anticipate here at Smartblock Law that the same position will be taken by regulators in Canada. So I hope that wasn't too detailed to begin with, but I'm going to be delving in now into specific issues. So before I do, is there anything in particular that you'd like me to focus on going forward?
No, not in particular. I guess to just have kind of like some kind of overview of how everything ties in together. Perhaps, what steps people should take going into the cryptocurrency market, what companies should do, etc.
Yeah. Okay. Well, I'll begin with some law, and then I'll talk about some practicalities.
Great.
And I should start by saying that everything that I say applies with respect to Canadian federal and Ontario law. And that's very important because in Canada, securities is regulated provincially. So that means every province has its own Securities Act. That's different from the States, where securities is primarily an issue of federal statute.
Mm-hmm.
Okay. Things work a little bit on the flip side on the tax end, but I'll get to that a bit later. So in Canada, what we found is that there are two ways that a token can be a security. And that's the initial question, is whether your token is a security. So the two ways are if it's an investment contract, and another potential way is if it's, at least in Ontario, is if it's a document evidencing property right. So I'll start first with the investment contract analysis. So the investment contract analysis came out of a case called Howie from the States in the 1930s. And we adopted the test in Howie here in Canada in 1970 something, in a case called Pacific Coast.
Mm-hmm.
And so essentially what you need is an investment of money in a common enterprise with profits to come significantly from the efforts of others.
Mm-hmm.
That's what an investment contract is. And if your token falls within that category, then it's likely that you're going to be caught by the Securities Act here in Ontario, and for that matter, all over the country and also in the States. So there are different ways that test applies in Canada versus the US. There are some subtleties that I won't get into here, but by and large, that's the general test. Investment of money in a common enterprise with profits to come significantly from the efforts of others. Now, that is only one way to be a security. You can also be a security, like I said, if you're a document evidencing property rights, and that's part of the definition of security in Ontario. And that's important because, in my mind, the blockchain ledger has potential to be such a document. Mm-hmm. Right? If the blockchain ledger is considered by a court to be a document evidencing a property right, then we're in trouble in terms of any token always being a security. So that's just something to watch out for. Now, in terms of practicalities, what I always recommend clients in the present regulatory climate is to approach our regulatory sandbox here in Ontario. So that's the OSC Launchpad. And the OSC Launchpad, they endeavor to work with blockchain companies so that there's securities compliance that meets the objectives of the blockchain company, which is to raise funds. And we're lucky that we have this sandbox regime up here in Canada. To my mind, I don't think they have something similar in the States. So in the States, I believe it's, get your opinion from a securities lawyer and proceed. And if there's an enforcement action, too bad you assume that risk. Whereas in Canada, you can work with the regulator. And if the Ontario Securities Commission or the BC Securities Commission gives you essentially a license to proceed with your blockchain-related activities, you are somewhat more insulated from the risk of a regulatory proceeding moving forward. Okay, so that's the general, scope of how ICOs and ITOs work up here in Canada and in Ontario. Very practically speaking, when you approach the OSC Launchpad, I always find it good practice to have a detailed budget of what you anticipate funds will be put toward. And I think that's very important because it helps to assure your regulator that the funds raised through your ICO or ITO will be kept in the blockchain company. It'll be, kept in the corporation. Because the big fear is that any funds raised will be absconded with or spent. The word pump and dump is a very popular term these days in ICOs, and regulators are very weary of risky securities investments. And so that's why I think it's very important to have a very detailed budget. So that would be my number one tip for an ICO. Have a detailed budget and a plan for what you're going to be putting your funds toward. Mm-hmm. So it legitimizes the fundraising effort. The second tip that I would have for an ICO or ITO is to demonstrate that you've put your mind toward operational considerations. So you don't want to get into a situation where you raise a whole bunch of money and you've got all this cash on hand and you know where you're going to put it, but you have not thought about operational regulatory compliance. And so for that reason, you might fall in trouble with respect to the taxman coming after you, or with respect to anti-money laundering issues, or with respect to various IT contracting issues, etc. And so if you can convince the securities regulator that you've considered these operational issues ahead of time, you may have an easier time convincing them that this is a bona fide venture and that your fundraising effort is also bona fide and that you don't plan to abscond with funds. So those are the two top tips that I have. So just to recap, one, have a detailed budget, and two, make sure that you can demonstrate to the Securities Commission that you've considered operational issues raised by your business plan.
Okay.
So that's on the fundraising side, and there are various variations on the major securities issues. You've got SAFT contracts as another way to raise capital.
Right.
You've got private placements, and you've got crowdfunding exemptions. These are situation-specific issues, and I raised them just to illustrate the fact that you don't just need to raise money through ICOs and ITOs. There are other avenues. There's traditional investment, private investment, and equity finance that you can use that mechanism to raise money. And so all of these options should be considered. ICOs and ITOs, they're not the only way for a blockchain company to raise money.
I guess people do like the idea also of, receiving international payments instantly. Perhaps if we're calling them payments, but in terms of say whatever the regulations would be in their jurisdiction for them actually, having to have a blockchain company registered and raising funds for that actual company and issuing out their token, so to speak, or coin for that matter.
Right. Well, you've sort of touched on the next area that I'd like to talk about, which is operational issues and anti-money laundering. Mm-hmm. And as I indicated before, you're going to need compliance in every jurisdiction where you've got securities activity happening and also where you're operating. So if your users, for example, reside in the US, if your users reside in the US and the company is located here in Canada, arguably you have to comply with the anti-money laundering rules of both countries. And If the users are say engaging in a smart contract permitted by your blockchain platform, and that smart contract involves other parties in other countries, well, you've got to make sure that you're compliant in those jurisdictions as well. Or at least you have to demonstrate best efforts to gain compliance. And so let me move on now to the next topic of operational issues, because this is where, I mean, securities is a big topic on the fundraising side, but operational issues I think are equally problematic these days and require legal attention and legal consideration.
Great.
So yeah, on the operational side, we have issues of cryptocurrency contracting to start with. So what that means is where you get into a deal in cryptocurrency. You enter into a commercial relationship, and you essentially treat cryptocurrency as money. And that's all well and fine in terms of what we all would like cryptocurrency to eventually be. We all, want it to be money. But in Canada, legally speaking, that's actually not allowed, because any commercial dealings with money have to be with respect to fiat currency. And right now, no cryptocurrency has the status of fiat currency. So what do? Well, we can still transact with each other with cryptocurrency, but we can't call it money. It has to be something else. And so right now, what's being done is we're calling the cryptocurrency a commodity, which is essentially a thing. It's a good.
Okay.
The complication when we transact with a good, at least in Canada, the complication is that we might be supplying, or rather we are supplying a good in the context of the GST HST scheme. So what that means is when you are contracting with another party and you are giving them cryptocurrency, technically, because you're supplying cryptocurrency, you need to be charging HST on that supply of cryptocurrency. And that's very counterintuitive, because if you think of any normal transaction, when you get into a deal with somebody and they pay you and you're the person receiving money, you don't expect to have to pay money on the money that you received, right? You don't expect to have to pay 13% HST on the Canadian dollars that you receive in that transaction.
Right.
So that makes, that's one of the bad consequences of cryptocurrency not yet getting the status of money here in Canada. Lawyers would have to be consulted in other jurisdictions to see if they have the same problem there. I know that in the commercial code and universal commercial code in the States, they have a similar definition of money that we have in our Currency Act. So without bogging down this conversation too much, I'll just leave it at this, that cryptocurrency, if treated as money, could result in an illegal contract, and nobody wants that. So there are ways to deal with it. I make various suggestions depending on the risk tolerance of my clients and depending on the status of the law at the time that I render my opinion. But there are ways to counteract this cryptocurrency contracting problem. Okay, so that's cryptocurrency contracting.